Hey everyone, welcome to Unchained, your no-hype resource for all things crypto. I'm your host, Laura Shin. On Wednesday, Roman Storm, co-founder of Tornado Cash, was found guilty of one charge, but the jury hung on the most serious charges the government brought against him. In this episode, I speak with former federal prosecutor Sam Enzer to break down what this verdict really means. You may remember him from our coverage of the SBF trial. What struck me about Sam's comments is that this verdict is not only weak for the government, but even for the one area where they did get a victory, the judge said that Roman had significant and strong grounds for a challenge. That, to me, increases the odds that this verdict may not stand as it currently is. Whatever the final outcome, it will be significant for crypto developers and also crypto businesses. The case raises questions that would have sweeping implications for the industry, particularly around the question of whether companies who develop crypto software and also operate front ends would feel safe continuing to do so. Sam explains the case from the very beginning, so if you are not familiar with it, don't worry, we break it all down. At Unchained, we believe the future should be decentralized, and that includes our data. That's why we use Walrus, the fast, dynamic, verifiable data layer. Learn more about the platform that's powering our future at walrus.xyz. One early Bitcoiner sold 30,000 BTC too soon, missing out on over $1 billion. Don't want to make the same mistake? With Xapo Bank, eligible members can get instant cash without selling their Bitcoin. Check out zapobank.com/unchained for more. Imagine an AI that speaks crypto and does the work of a team of analysts. Trusted by 80+ institutions, now open to serious traders like you. Visit askfocal.com. Heads up, everyone, we've got exciting news. Bits and Bips, our macro meets crypto show, is officially spinning off into its own podcast feed, YouTube channel, and X account. If you've been enjoying the deep dives into interest rates, monetary policy, and how they intersect with the crypto markets, make sure to follow Bits and Bips wherever you get your podcasts, on YouTube and on X. You'll find the links to YouTube, X, and other podcast platforms in the show notes. If you're watching this, there's a QR code on screen. We'll be posting here for a few more weeks, but starting in September, Bits and Bips will launch on its own feed. For now, we will publish longer clips from the show on those accounts. Remember, go to the show notes now and subscribe to Bits and Bips, that's Bits, +Bips, spelled BIPS, on YouTube, X, and wherever you get your podcasts. Welcome, Sam.
Thanks, Laura. Great to see you again. Thanks for having me on.
Yeah, nice to see you. So a verdict was delivered in the trial for Roman Storm, the Tornado Cash developer, yesterday. Obviously, it seems that it was somewhat of a win for crypto, though in my opinion, it was also kind of confusing because in my opinion, it may contradict existing regulatory guidance. But before we get into all that, Sam, why don't you give us the background on who Roman Storm is and what he was being tried for?
Sure. And it is a fascinating case with huge implications for the industry. Roman Storm was one of the three co-founders of a company called PepperSec, which was the entity that developed the Tornado Cash software. Is an Ethereum-based protocol that is supposed to be a privacy tool. It allows users to send their crypto assets to a pool where the funds are commingled with others, which obscures the source of the funds. So if somebody's tracing the chain, it would obscure your identity or that you were the one who sent it in when the funds leave. And that has legitimate purposes, but it also can be abused by criminals to obscure the source of criminal proceeds. And so this case was about whether Mr. Storm had violated money laundering, money transmission, and sanctions laws in a criminal way, in a willful and intentional way, through his role in operating this business.
And so what were the charges?
That's a very interesting question because the charges that were initially brought, the government didn't proceed on all of them. So originally, during the Biden administration, which had a very different approach to the crypto industry than the Trump administration that we're in right now, during the Biden administration, my former office, the Southern District of New York, where I used to be a prosecutor, obtained an indictment accusing Roman Storm of 3 counts. Count 1, conspiracy to launder money, to launder proceeds of certain specific crimes. And those crimes included a conspiracy to use Tornado Cash to launder the proceeds of hacks and frauds in the crypto sector. Count 2, which is the most important count, and the count that Mr. Storm was ultimately convicted of in part. Count 2 originally, during the Biden administration, charged Storm with conspiring to violate the laws against operating an unlicensed money transmission business in 2 ways. 1, conspiring to operate Tornado Cash as an unlicensed money transmission business, full stop, which is a technical registration crime. And separately, conspiring with others to operate Tornado Cash as an as a money transmission business with knowledge that some of the money being transmitted with this business was criminal proceeds derived from crimes. And then count 3, conspiracy to violate OFAC sanctions, and specifically the sanctions on North Korea, because there was evidence at trial that the Lazarus Group used Tornado Cash to launder proceeds of the infamous Ronin hack arising from Axie Infinity. So those were the original charges. During the Trump administration, the new Deputy Attorney General, Todd Blanche, who is himself an alum of the Southern District and used to be President Trump's personal lawyer in certain matters, Deputy AG Blanche issued a memorandum in April changing the guidance on how the Justice Department would approach prosecutions in the crypto sector. And in particular, he explained in the memo that he did not want prosecutors in the Justice Department to prosecute crimes against market intermediaries like centralized exchanges, decentralized exchanges, software developers, arising from registration crimes, technical crimes, failure to register as a money licensing or money transmission or money service business, for example. So after that guidance, there was a back and forth, and we don't have visibility into that. It's not all public. But we know there was a back and forth between the defense lawyers representing Mr. Storm and the government. And ultimately, the government wrote a letter to the court, Judge Fela in the Southern District, explaining they were not going to proceed to trial on the conspiracy to operate Tornado Cash as an unlicensed money transmission business. They dropped it. They're not proceeding on it. They didn't bring it to the jury. But the other counts, they did proceed on. And in the end, the jury returned a partial verdict after a long trial and extensive deliberations with lots of ups and downs. They convicted Mr. Storm of conspiring to operate Tornado Cash as a money transmission business with knowledge that it was used to transmit or transfer funds that were derived from crimes. And they could not reach a unanimous verdict on the other counts, the money laundering conspiracy count and the sanctions evasion conspiracy count. They didn't acquit, they didn't convict, they hung on those counts.
So I was not able to follow the trial closely, but from what I could glean, at least it seemed it didn't go well for the prosecution. And I have an awareness. Of course, I'm getting most of my info from through this crypto lens. So maybe that's like a slanted view. But I was wondering if you could talk a little bit about those various ups and downs at trial.
Yeah, I think that those accounts are correct in the sense that, and the verdict bears that out, the outcome. This is a very weak verdict for the government. And I say that because there are very significant legal problems with the count that the jury did convict on. Most notably, and I think you alluded to this earlier, Laura, in 2019, so before Tornado Cash was launched, there was guidance from the Treasury Department's Financial Crimes Enforcement Network, FinCEN, guidance that laid out sort of how the Bank Secrecy Act and money transmission laws and regulations apply to crypto and how they do not apply to certain activities that we would typically call DeFi or decentralized activity, right? And one of the things that's critical in that guidance is the notion that if you're a developer of software and you develop non-custodial software that allows peer-to-peer transfers of digital assets, which is what Tornado Cash did, that is not money transmission activity. In other words, the regulator who is charged with overseeing how this statute is applied at the federal level and who does and doesn't have to register with FinCEN as a money service business said this type of activity, or at least what the defense said was the type of activity that Roman Storm was engaged in through his business and through Tornado Cash, are excluded. And yet the jury found that they conspired to violate it. And I think there's going to be significant motion practice after the verdict to ask the judge for a new trial, to overturn the verdict, or direct a verdict of acquittal. And if the judge doesn't grant that relief, there'll be a significant litigation at the appellate level on this question. Because one, Storm and the software and PepperSec did not have custody of the digital assets that were being mixed through the service, okay? And that is critical for whether or not someone is acting as a money transmitter. And another issue with the government's theory, PepperSec and Tornado Cash, the software or the user interface, did not get transaction fees. So a typical money transmitter like Western Union, they'll receive money from someone, they send it to somebody else, and they charge a fee. They get a commission base. That's not what happened with Tornado Cash. There was no fee. Okay, so how can you have a money transmission business when there is no business? They had an indirect monetization model. So in fairness to the government, their argument was that PepperSec or Roman and others launched a token, the Torn token, and that the sale of the tokens, in the government's view, was an indirect way of monetizing whatever was happening on the Tornado Cash protocol. But I think, is that correct under the law? There's significant room for debate about that. And there's significant room for debate about, even if this is activity that you would say violates the statute, is it fair and appropriate to put somebody in prison when there may have been a lack of fair notice as to whether what they were doing was legal? That is a problem under the due process clause of our Constitution.
Yeah, and one other piece of this is just, I don't even really quite understand how they were even able to bring the charge if the guidance from the regulator is that if you don't have custody, then you're not a money transmitting business. So can you even explain how that was able to go through?
Yeah, the FinCEN is an arm of the Treasury Department, and they interpret laws, but their interpretation is not binding on the Justice Department. And I think what the Justice Department would say, or at least what the prosecutors would say, is, look, that guidance is what it is. We don't think that it applies to what Roman was doing. He was doing more or doing something different than what is excluded within the text of the FinCEN guidance. So that would be their argument. That's their position. It has to be. But, the jury wasn't told about some of this back and forth. And I think those of us who've been following this case publicly know that the Treasury Department's Office of Foreign Asset Controls, OFAC, which is the body that issues sanctions, they sanctioned certain wallets, or I should say smart contract pools that were used by the Tornado Cash protocol as the vehicle for mixing funds. So they were sanctioned, and then there were several litigations challenging those sanctions. Ultimately, the Fifth Circuit, one of the intermediate appellate courts in our country that sits between trial courts and the Supreme Court, decided that OFAC and the Treasury Department had exceeded their statutory authority, that they did not have the power to sanction a smart contract protocol software. They can sanction a person, they can sanction property, but the protocol, the smart contract addresses, are not a person and are not property, and so they cannot be sanctioned. And then OFAC ultimately lifted the sanctions. Now, I think all of that uncertainty, the defense wanted to admit that to the jury, and the judge said no, it would confuse the jury. But I think there will be a debate about whether or not it was proper to exclude some of that evidence, which goes to the question of, did Roman have clear notice of what the government says the rules were? Did he knowingly violate them? And is it fair, as a matter of fair notice and due process, to put him behind bars in a situation like this?
Yeah, I mean, so I wasn't there for the arguments around this, but just knowing what I know, it feels like they should have been informed of that. But anyway, so we're gonna talk a little bit more about what happened at trial and also unpack the verdict. But first, a quick word from the sponsors to make this show possible. At Unchained, we care about the future of decentralization. So it only made sense for our media content to be decentralized. That's why we use Walrus. It's the fast, dynamic, and verifiable data layer for on-chain builders. And it's not just data management. Walrus ties directly into smart contracts, unlocking new possibilities for programmable content delivery, subscriptions, and community engagement. So as we imagine what decentralized media can become, Walrus is the tech we trust to help build it. Learn more at walrus.xyz. Selling your Bitcoin just to get cash? One early Bitcoiner did and missed out on over $1 billion. With Xapo Bank, you can access up to $1 million instantly without selling a single sat. Eligible Xapo Bank members can borrow up to 40% of their Bitcoin's value. No stress, no selling, no buying back in. Use it for what matters most. Your dream home, your child's education, a getaway, or that can't-miss investment. With Bitcoin-backed loans, you're in control. Set your installments and repay in Bitcoin or US dollars, your choice. Enjoy competitive rates, zero fees, flexible terms, and no penalties for early repayment. And your Bitcoin stays safe, never rehypothecated, relent, or pooled. It's securely held until your loan is repaid. Check them out at zapobank.com/unchained. Looking for your next big trade? Want to track every move in your portfolio, news, unlocks, price action, and open interest in one place? Meet Focal, your personalized AI assistant for crypto. Built for institutions, now open to serious traders like you. Focal surfaces high signal insights, automates your workflows, and helps you move faster in 24/7 markets. Find out why the smartest desks use Focal to stay ahead. Sign up at askfocal.com. Heads up, everyone, we've got exciting news. Bits and Bips, our Macro Meets Crypto show, is officially spinning off into its own podcast feed, YouTube channel, and X account. If you've been enjoying the deep dives into interest rates, monetary policy, and how they intersect with the crypto markets, make sure to follow Bits and Bips wherever you get your podcasts, on YouTube, and on X. You'll find the links to YouTube, X, and other podcast platforms in the show notes. If you're watching this, there's a QR code on screen. We'll be posting here for a few more weeks, but starting in September, Bits and Bips will launch on its own feed. For now, we will publish longer clips from the show on those accounts. Remember, go to the show notes now and subscribe to Bits and Bips, that's Bits, +Bips, spelled B-I-P-S, on YouTube, X, and wherever you get your podcasts. Back to my conversation with Sam. So during the trial, I think like one of the very first things that happened that was, a sign that maybe things weren't going to go well for the government was the fact that I guess one of their very first witnesses may not have even had a transaction that even connected to Tornado Cash at all. Can you talk about what happened there?
So the government called several types of witnesses to prove their case. Some of the witnesses were victims, folks who were victimized by a fraud or victimized by a hack. And then their argument would be that the proceeds of the fraud or hack were laundered by criminals through Tornado Cash, and that the victims complained to Tornado Cash, or they emailed the founders, including Roman Storm, and so the government wanted to say that put the government put Storm on notice of the criminal laundering, use of criminal proceeds, sanctions evasion. But there were all kinds of snafus during the trial. One of the victims, it turned out, had not connected up the way that the government said. Others, another sort of snafu in the trial, I think the government called criminals who had used the protocol to launder funds. And in many instances, those criminals were, I think in the jury's eyes, worse human beings than the guy they're trying. And that's a thing that prosecutors talk about as that is referred to as cooperating down, taking somebody who's a bad actor and letting them work off their sentence, get a reduced sentence by testifying against somebody who is a smaller fish than them. As a legal matter, it's allowed. There's nothing wrong as a legal matter with that. But as a tactical matter, I think experienced trial lawyers know juries find that distasteful. They don't like it. They don't think the prosecution should do it. And very often, they will express their discontent with that strategy, the cooperating down thing, in the way that they approach the verdict.
Okay, that's really interesting. So, as we mentioned, this verdict is, sort of mixed, but I think, more on the positive side. So, what would you say is the significance for crypto developers like Roman Storm, but also for the wider industry?
So the case isn't over, and we need to see how the challenges to the verdict play out and what an appellate court says before we kind of land on the conclusions. But I think one sort of there's a few lessons, right? One lesson is for developers, it is critical that if they are going to develop software and let it go into the world, you know, if they're going to defend themselves by saying, I developed the software and I don't have control over whether other people abuse it, then they need to be very clear that is in fact their role, right? Roman, I think that was a big piece of his defense. His defense was, I developed this, the software does what it does. If people were abusing it to launder money, I can't stop that. The problem is he had continuing engagement with the software. He was running a user interface. They were launching the Torn token, and he's getting communications about victims having issues. And so the government argued to the jury, and was allowed to argue to the jury, that he could have done things, introduced compliance features, and didn't. And they said that was evidence of his intent, that he wanted this to be used as essentially a money laundering service, a way to wash dirty money. The point there being, if you're going to be a developer, then you need to keep to that role and not also run a business that continues. That could be done by some separate entity, right, to keep the lines clear. It's important that people think about the compliance aspect of it. The things the government argued, like using geo-blocking to block folks in sanctioned jurisdictions. None of it's perfect, but if they had been done from the beginning, I think that is evidence of good faith that can be used, and failure to do it can be a problem. And then another thing was just, there were a lot of unfortunate communications. Some of the most damning evidence against Roman were chats, Signal, Telegram, emails, where he's talking to his co-founders, and he's being very candid, and probably speaking at a time when he's emotional, right? And in a trial, that can be taken out of context very easily by the government. So it's really important to be thoughtful about what you're saying in writing. Like, I always think I love Game of Thrones, and in the Game of Thrones series, there's this trial of the Lannister, I'm forgetting, Tyrion Lannister is tried for a crime he didn't commit, the murder of his nephew, who was the king. And they call a parade of witnesses who relay a nugget of truth, a comment he made here, a thing that happened there. And it's true that they happened, but the context in which they happen is completely different from the way it's presented in this quote unquote trial. And when the government is shooting 100 bullets at you, 100 out of context statements, you can't sit there and tell the jury, well, that's not what I meant. 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 Eventually, it's going to fall on deaf ears. I mean, ultimately, you have to do that. And I think the defense did a very good job of doing that. But it's very difficult. And the best way to avoid that is to not say dumb stuff in writing, right? Be careful. You have to, when you put something in writing, it's like putting it in stone. You need to think about how this could be viewed under a microscope later.
Yeah, I mean, the one part that you said about how, like, it's one thing to write code, it's another thing to make a business out of it. I mean, most companies that are developing, and it's not even just in crypto, like most, if you look even at like the Mag 7 or something, like developers write code and then that's used in the business. And, even something like Uniswap, like, yeah, they have developed the technology, but then they also run a front end. So this is something, yeah, that is a pretty common model in the industry. And frankly, makes sense just from like, just from how anybody would do a business sort of perspective. So I did also want to talk about how there's a number of related proceedings that have been happening in parallel. Um, you know, like OFAC sanctions. There's the Samurai case, which that was a little bit of a surprise event right before the jury went to deliberations. But explain what's been happening with those and how that could impact the case going forward.
Absolutely. But before I do, let me just comment on what you said a moment ago, Laura. I want to make sure that what I was saying is clear. I think if you want to get the protection of the FinCEN guidance for being a software developer, you put that in danger when you do more and you continue to run a front end. There's nothing wrong with running a front end, but now you have to deal with other areas which are also excluded under that guidance. And what I would say there is, I think what we're seeing from the government, there is a push and pull, right? If you run an ongoing business that profits from activity that is happening on a decentralized protocol, on an automated protocol, the government is going to complain that you need to have some type of compliance. What does that compliance look like? That's evolving. I think it is understood right now that know your customer requirements are not required, or at least the government hasn't said that it's required in a situation where it's non-custodial and fits within the 2019 guidance. But that is the debate happening right now. Unfortunately, the Clarity Act in Congress doesn't address that particular issue. So anyway, how that gets regulated, how that gets sorted out, we'll see over the next few years. Now, to your question about the other proceedings, it's a tortured history, but basically, OFAC imposed sanctions. Several litigations were brought, one by Coin Center, some by users of Tornado Cash, saying, look, these sanctions are illegal. The Treasury Department doesn't have the power under the statutes that allow them to set forth sanctions to sanction software. They can sanction a person, they can sanction property, they cannot sanction software. The Fifth Circuit agreed, and then OFAC delisted, they took away the sanctions that were imposed on the smart contract protocols. I think that's the quickest summary of what happened in the other proceedings. And it just shows, I think this case is at the center of some very difficult questions about, okay, the government and society have a legitimate interest in making sure that criminals cannot easily move criminal proceeds. On the other hand, we can't have makers of software, manufacturers of goods be held criminally liable when other people abuse what they made. Where's the line in between? And that is now front and center as this case continues to move through the district court and maybe the Second Circuit and potentially the Supreme Court. And it will be front and center in Congress.
Okay, so what are the next steps exactly? Like, I think so they're going to appeal Roman's team. So what are...
Before we even get to an appeal,
Uh-huh.
the Roman gets to move for a new trial or a judgment of acquittal. I think that's the next thing that will happen. And there will be briefing on that. The judge, Judge Fela, will rule. If she rules that the conviction was proper on the one count, we could proceed to sentencing. The government could retry Roman on the counts where the jury hung. So it is possible that they could be retried. Or the judge could say, I think the conviction was inappropriate, and could say that on the counts that the jury hung on, those should have been acquittals. And if either of those extreme outcomes, after the case has made its way through the district court, it could go up on appeal. And who appeals will depend on what the outcome is. If the government's upset with the outcome, it'll be them appealing. If Roman's upset with the outcome, he'll be appealing.
Okay. Yeah. I mean, one question actually, just how frequent is it that the jury will, or there will be a hung jury, I guess, on certain charges? Like, is that common or uncommon?
It's not, I wouldn't say it happens. It's not the norm in the Southern District of New York. In the Southern District of New York, the government chooses its case, right? They decide, they investigate, they're alerted to many things, they investigate, they decide whether they're going to proceed to trial. So if they're going to trial on a case, they think it's strong. So it is rare, but it happens. And this is one of the most extreme, or one of the most rare situations, which is a partial verdict. We've got a verdict on one count and an unknown, a hung on the others.
Okay. And last thing I just wanted to throw in there about some of the ups and downs. That whole thing with Dragonfly Capital is so interesting, where the prosecutors kind of let it be known that they were considering bringing charges against Dragonfly Capital for investing in PepperSec. Was that just a blunder, or do you think it was meant to be, like, was that purposeful, or how do you interpret what happened there?
I think sometimes it all depends on what you mean by considering charges. Very often, the government will interact with people that ultimately it's not going to charge, but that they're involved enough in activity that they're considered what's called a subject. In other words, they're not a target. They're not somebody the government is focused on charging. They're not a mere witness, like a bystander to a shooting. They're somebody who has knowledge of activity, but might have some exposure. And whether they have exposure will depend on what the evidence shows in their investigation, in the government's investigation. So it is possible, and I don't know all the circumstances, but it is possible that, the government conveyed that Dragonfly was a subject, which may not have meant that they were going to that they actually intended to prosecute them.
Huh. Okay. So, yeah, I guess, as you look forward at what might happen, like, what do you think the crypto industry should be on the lookout for? And, depending on how things go, like what do you think would be ideal for the industry?
I think what would be ideal is a verdict, a ruling from the court that this software was not conducting money transmission activity, because the software, or the developers of the software, or the folks running the front end, never had control of the funds. The users had control to send the funds into the pools, and only the recipient of this secret code could then move the funds out. And that was never Roman. It was never the co-founders. It was never PepperSec. So that's non-custodial, and that money transmission rules should not apply to non-custodial activity. Also, I think it would be very nice to see a ruling that you can't be guilty of running an illegal money transmission business when there's no business, when there's no profit, no fee from the activity. To say that you could be running a money transmission business by having indirect monetization through a token, I think is a bridge too far. It's just not sound under the law. So I think those are what I'd like to see. And frankly, I think whether it's Judge Fela, after the verdict, the government moved to have Roman Storm detained pending the outcome of sentencing. And she rejected that motion. She said he's not a flight risk. And part of her reasoning was that Roman has no incentive to flee because there are significant and strong grounds to challenge the conviction. All right. Does that mean she's actually going to throw out the conviction? I'm not saying that. I can't read the tea leaves to predict that. But she recognizes that there's a significant legal issue. And thus, it's not so clear that this conviction is going to stick. I mean, I think this is a very, very close case, probably 50-50 as to whether that count of conviction sticks.
Okay. All right. Well, I guess we'll be glued to our seats seeing what happens. And actually, just so for these next steps, like, what is the timeline for them?
So the judge is going to set a schedule. She may have already, but she's going to set a briefing schedule for a motion to challenge the verdict and for a new trial. So the defense will make their motion, the government will oppose it, the defense will probably get an opportunity to submit a reply, and then the judge will decide that. If the case still has a conviction, it will proceed to sentencing, which could be at a time set by the court. If she tosses the conviction and orders a judgment of acquittal or a new trial, if she orders a judgment of acquittal, then I think you're going to go directly to appeal. If she orders a new trial, then we're going to have a new trial.
Okay, wow. All right. Well, Sam, it's always great to catch up with you. Thanks so much for sharing your insights with us on Unchained.
Likewise, thank you for having me.